The law is divided into two branches or types, civil and criminal, which have different purposes. An incident may give rise to both civil and criminal consequences. In criminal law, if minimum legal standards are not met, the enforcing authority may prosecute the offender in the criminal courts. In civil law, if an individual suffers a loss, for example, injury, ill health or death, the victim or their dependents may sue for compensation in the civil courts. Consider an accident where an apprentice carpenter cuts off his fingers using an unguarded bandsaw. He may well take civil action against his employer, blaming the employer for negligently causing his injury by not fitting a guard to the saw, and seeking compensation, referred to as damages, for his loss. If the civil courts found in favour of the worker, the employer would need to claim against their employer's liability insurance for payment of the damages. Criminal prosecution may also be taken by an enforcing authority such as the HSE or the local authority. The purpose of the prosecution would be to punish the employer through a fine and/or imprisonment for failing to comply with health and safety legislation, i.e., the guarding requirements of the provision and use of work equipment regulations. Breaching health and safety legislation is a crime, and there is no insurance against the punishment.